You're listening to the Subrogation Support Network, a podcast from Wickert and Layer, America's subrogation law firm, with dissemination of new developments and changes in subrogation law, as well as emerging trends and best practices. Here's your host, Ashton Kirsch.
Hello, everybody. This is Ashton Kirsch, your host, with today's episode of the Subrogation Support Network podcast. I am here today with my partner, Gary Wickert. Gary, how you doing today?
Doing good, Ashton. Thanks for having me.
Excellent. Well, Gary's joined us on a few episodes in the past. He actually, I believe you even hosted an episode on this, and I believe you've offered to co-host for me in the future. So, great participant. Gary is, one of the founders of modern day subrogation. I mean, he's really integral in, where subro has become, where it's gone, right? From the subro department being back behind the water heaters in the basement to maybe somewhere up on a higher floor. But I think that that's really something Gary has done so much, obviously, for the industry and also for me as a mentor as I've developed my career in subrogation. Gary, tell us a bit about, what's new with you? What's going on?
It's funny. You just flipped a switch in my brain when you talked about the way subro used to be. You and I have been making efforts and inroads into the London market, the Lloyd's Subrogation Network. And it's just astonishing to see where we've come from and where we are today. I remember traveling to London and talking to some of the underwriters there, the syndicates, the London market companies, and realizing that they not only didn't pursue subrogation, they didn't understand what it was, and they had no recovery personnel at all. It was the forgotten stepchild. And it is fun, and your comment reminded me of this, how far we've come in developing this sort of recognition and attention that we pay to subrogation and the effect that it has not only on the insurance companies, but on society as a whole. And that is extremely true in both health insurance and work comp. So, yeah, interesting.
I can say even when I first started practicing a little over a decade ago doing subro work, I'd still have clients here and there, bringing them in and you find out, hey, they're asking us, what is subrogation? Not just what are better practices, better procedures, but just kind of, hey, can you explain what this subrogation thing is to us? It's like, wait, you're not pursuing any subrogation? And the answer was sometimes, yes, exactly. And, full disclosure, I was one of the most lucrative pieces of business where we could come in and say, hey, you remember how you had $0? Well, here's a check for $10 million at the end of the year, throughout the year. We don't see that as much anymore. It's more now about, hey, they have a subro department and it's just maybe not optimized. But I think you're right. There's so much more attention. It's an amazing place to be. We're no longer back behind the water heaters. I think it's pretty cool, right, Gary?
If you go to our website, and I'm not necessarily drawing people to our website, but there is a video that we have on there that shows a clock that's running backwards, and it shows video of auto collisions, explosions, all running in reverse. And the theme of the video, and it's very short, and it's well done. The company that did it for us did a wonderful job. But the theme is time travel for the insurance industry. And I think when I first woke up to the benefits of what we do in the world of recovery, I realized that this is literally the erasing of catastrophic losses. While we can't erase injuries, permanent debilitating injuries, explosions, fires, all of that, those losses, which are what insurance companies have to deal with on a day-to-day basis, can be erased. And so the concept of time travel, going back to prior to the incident, the loss, I think that's very real and very apropos.
Absolutely. Yeah. And it's tax-free money, right? It's money coming in, money that they, paid out. And they, frankly, a lot of these carriers never really expected to see it back. And that's where this is so important. And kind of tying this into the topic that we're going to discuss today, which is some legislative changes in Nevada and Nebraska and kind of recent, be it revamps of insurance codes, work comp codes, and so forth And what we're kind of seeing going forward, it kind of ties directly into that, in similar function and manner as the carriers didn't give subro attention. A lot of times the state legislatures, they kind of didn't even consider it when writing the work comp code, when, putting together how work comp subro or any other sort of subrogation, the recovery is going to be allocated. And you're seeing more and more attention on that on a go-forward basis. You're seeing it from kind of both sides. You're seeing some state legislatures realize that the plaintiff's bar has gotten a little bit ahead of themselves, and they're really taking advantage of the insurance carrier to get their client a double recovery. But then on the other side of that, you see other state legislatures who are looking and saying, hey, why are we paying off these insurance carriers all this money when there's an injured party out there? So that's kind of what I want to talk about today, is generally and conceptually how this works, what we're seeing happen, and also get into some of the specifics that the claims professional can use as it relates to Nevada and Nebraska. Right, Gary?
It's interesting that you mentioned that, because I know you are politically active, and a lot of folks in not only the Wisconsin legislature, but in Congress as well, and as do I. And I have asked them for help in the field in which we practiced in the past. To put the irony in perspective, I would wager that if you wrote to every member of the U.S. House of Representatives and every senator and every legislator in the bicameral Wisconsin legislature or the unicameral Nebraska legislature, and ask them a simple question, no cheating, can't look at your phone, what is subrogation? What percentage of them would have a positive response? Oh, I understand what that is. That's when the insurance company pays and you get your money back, and here's the reason for it. I would wager, and I don't mean to disparage anyone who's in public service and who's has the task of making laws. It's not easy. But I would wager that the percentage is somewhere in the 10% to 15% range. Unless you come from an insurance background, or you're in charge of a committee, you're on a committee that deals with insurance regulations, I doubt that most of these legislators even know what it is that we're talking about. And that is alarming, in my opinion.
And I have tested that theory. I do have several friends who are elected representatives, and I've asked, they know their stuff because frankly, they know what I do, and maybe that's why they know it. But I have asked others who I've met who are in elected positions, as I won't say lobby. We are not lobbyists. We cannot lobby, but we can advocate for our interests, which we will do. And I've asked a lot of, be it state legislators or also some of local congressmen, tell me what you know about it. And the answer is, what's subrogation? Explain this to me. And kind of blown away by this. And it's really kind of it's politically agnostic. But then again, there's two ways to kind of look at it that's tough, right? Sometimes they'll look at it and say, oh, this big bad insurance carrier is trying to just take money from the little man. And the other side of that same person, as they start learning more, is going to realize, wait, hold up, no, they've paid this out. The claimant should get a double recovery on the comp end. And in doing so, we're able to keep premiums low and help small businesses, right? Work comp is one of the top line items of expenses for a small business in the United States. So this stuff is really important. It's pretty juicy once you start digging into it. But the problem is it's really niche. So it's hard for these elected representatives to kind of develop any sort of requisite expertise aside from kind of the talking points they're used to.
Oh, this could be a topic unto itself. But, it's interesting that, if you're going to look at this from a political perspective, and you really have to when you're talking about what I think you want to talk about today, which are some legislative efforts to help improve subrogation and in turn help improve the cost of insurance in this country, specifically work comp. You do get into these issues of, okay, well, are Republicans and more conservative leaning politicians more favorable to the insurance companies, or are Democrats and more liberal, progressive leaning lawmakers more amenable to and considerate of the needs of trial lawyers who represent injured victims? If you talk about tort reform, Yes, I think that there's a pretty accurate division that can be drawn along political lines, obviously, because plaintiffs' lawyers make their living with litigation and personal injury cases, et cetera, and tort reform is the enemy of that living that they make. However, when you get to subrogation, I have found that the line is not so starkly drawn. For example, if you look back at one of the most landmark subrogation decisions in American history, it would be the 2002 case of Great West Life and Annuity Insurance Company versus Knutson. And it revolutionized health insurance subrogation and ERISA subrogation. The 5 justices who were on the Supreme Court who ruled in favor of the insurance company were all appointed by Democrats. And the 4 justices who ruled against subrogation were assigned by Republicans. And to me, that doesn't necessarily say it's apolitical, but it does say quite emphatically that it doesn't follow party lines. For example, one of the knocks against subrogation, and if Republicans don't want subrogation, if they vote against it or fail to take action in favor of subrogation, sometimes they do so by saying, well, it just creates another lawsuit. You have an accident, there's an insurance claim, and then our already congested courts are now clogged with yet another tort case filed in state court in some state in our country seeking recovery of $13,000 in collision damages. And we don't want to see our courts clogged. They are more anti-litigation. So it does cross over and does jump on both sides of party lines.
Which is funny because actually Jim Busenlander and I had a podcast that is going to be released before this one. I think it's coming out this week. Actually, today, it's the 5th, where we talk about some of the tort reform in Louisiana. And one of the interesting things we discussed was how unique it is that tort reform will oftentimes really disturb or make subrogation more difficult. So you have kind of the subrogation side of the insurance company pushing for one way, while the insurance company in whole is pushing another. So, I mean, it's confusing, right? And another reason why a lot of times maybe you said, some of the Republicans will support this, Democrats that, even though it doesn't really make sense. That's a question of also whether they even know what they're talking about in this regards. But I guess that's a whole nother conversation that we don't need to have on the air. But no, I think it's interesting stuff. And that's why this is so important. I know that you, Gary, so many other people at our firm, we're kind of in a unique position because insurance carriers will come to us. Industry groups will come to us. And while they don't ask us to lobby, they may ask us to actually draft legislation and assist them in, putting together the right rules that'll maximize not just benefit for recovery, but just societal benefit in general. So in having done so, I think that Gary's a really unique person to be able to speak on Nevada, Nebraska, and maybe a few others that jump in there as we go forward with this today.
That's true. We have, I have written, and we'll talk maybe about some of these other states a little bit later in the podcast, but I have written to legislators in other states trying to explain why a problem with their current legislation is costing their small businesses. I wrote an editorial in the Missoulian, which is the Missoula, Montana publication a number of years ago, and it had to do with, I think the headline was Montana Governor Sides with Trial Lawyers, which really, the conservative governor of Montana at the time, it really rankled him because it doesn't look good in print. But what he did was he vetoed legislation which would have greatly improved the ability and the efficacy of subrogating in that state. Yes, we do get involved every once in a while in trying to point out where things could change. And one example of that is in Nevada, where...
And let's jump into Nevada, Gary. Tell me a bit about the state, what's going on, those changes, so that we can get the audience up to speed as to some pretty controversial and kind of very confusing recent developments.
We have written an article. In fact, it's been updated several times that our listeners can find online, called the 10 best and 10 worst states for workers' compensation subrogation in America. And it's a moving target, slow moving target, but it's a moving target where we evaluate and sort of give kudos to the top 10 states where subrogation is the easiest, the most efficient, and where it helps small businesses keep their workers' compensation premiums low. And then we also, conversely, discuss the 10 worst states and why they're bad and why changes need to be made. Nevada had consistently, and in every one of those publications, been in the bottom 10. And the reason for it had nothing to do with the Nevada legislature, ironically, but it had everything to do with the Nevada courts. So when we talk about a state having bad subrogation law, we have to remember it's not just the legislators that have a role here. It's also the courts, state courts, appellate courts, state Supreme Courts, federal district courts, federal courts of appeals, and even the U.S. Supreme Court, as we just discussed in the Knutson case, all play a role. And in Nevada, the problem was that while they had a fairly sound statute, which allowed workers' compensation subrogation with some, but not a lot of significant obstacles and hurdles, the Nevada Supreme Court, which at the time, and again, political makeup of these courts, usually in the state, there's 7 members of the Supreme Court, it varies, but in Nevada, the members of the Supreme Court were primarily interested in making sure that injured victims had all of the rights and had all of the easy route to a large recovery. And they basically threw work comp under the bus. In Nevada, the Supreme Court said in a case called Paremba versus Southern Nevada Paving, which is one of the worst activist state Supreme Court decisions I have seen in my entire career spanning 4 decades. They basically went to Washington and took a horrible case from Washington and brought it down to Nevada for some reason, and essentially decided that the future credit that a work comp carrier, again, we're assuming some familiarity with work comp subrogation, but when there's a third-party recovery and the plaintiff recovers a sum of money, that money, the net money that he puts in his pocket when everything is said and done, is and should be a statutory credit with which the work comp carrier can then take advantage of. And the Supreme Court back in 2016 said, no, we're going to allow that future credit to be used up and exhausted by literally anything that the injured employee or his family spent money on, including living expenses, groceries, mortgage payments, vacations. Well, and if you think I'm making this up, you can look at the decision. So we had a horrible decision which really put Nevada on life support when it came to subrogation. What we did was, and we, when I say we, I mean Matisse and Wickert, have been asked for our opinions in a number of states. Number one, because we have done this for a long time and are well known in the industry. Number two, because our headquarters, Ashton, where you work out of in Hartford, Wisconsin, is located in the state with the second best work comp subrogation paradigm in the country. So a lot of other states look at us and say, we want our employers, our small businesses, to be able to make a subrogation recovery so that its risk modifier, the loss history of that employer, is lowered and its premiums are therefore lowered. And we know that work comp premiums for a small business is, next to payroll, the largest single expense that a business has. And when they go out of business or make a determination that they can't survive, it's often not just salaries, but often work comp premiums that put them under. So we had a situation in Nevada where we were asked our opinion, and there was a bill that was passed effective on May 31st, 1925, that sort of turned the tide there. Senate Bill 258 was introduced and driven by this judicial activism, inconsistency, and confusion. The legislature got its head on straight and rewrote completely the statute, taking Nevada from one of the worst states for work comp subro, i.e., how easy it is for an employer to keep its premiums low, to one of the best states. It was amazing.
Absolutely. Absolutely. And the sheer number of questions that we had come through the firm, and I think as a lot of people that are in the audience know who work with our firm, all of our attorneys are available just to answer client questions, typically at no charge, but also we have a ask a question button on the website where you can just ask questions. I think for a good 3-4 months, 40% of the questions were all related to Nevada work comp and the changes, because I think the gist of it is, hey, correct me if I'm wrong on this, Gary, you are the expert. Initially, we had the Breen formula. From there, court case drops, arguably putting that in question as to whether or not that's the case, almost to, in a way, benefiting the comp carriers. We're in this strange, crazy, no man's land of nobody knows where things are going. So clients are asking, hey, plaintiffs' attorneys are claiming that the formula still applies. Others are saying it doesn't. What do we do? Then we have the legislature that steps in and oftentimes makes things worse. But, then they give some consistency here. And that's kind of where we stand. Is that correct in a nutshell, or am I missing something there?
No, it is. And I think what we have to be clear on is the fact that the insurance industry didn't receive a home run in Nevada. They took Nevada from a state in which the state legislature and the workers' compensation program and statutes that they had there had been hijacked by the Supreme Court, a pro-plaintiff Supreme Court. They took Nevada and worked a wonderful compromise, a compromise where both pro-plaintiff Democrats and again, we paint with a broad brush, pro-insurance industry Republicans all agreed that there was not a clear winner. But what they did is they restored common sense to Nevada. They came up with an entirely new statute, which I could best describe as a common sense, amicable compromise on the issue of work comp subro. Plaintiffs don't want it. They feel insurance companies get paid a premium. They should be responsible for making the payments. That's what they get paid for. On the other side, people realize that, hey, the cost of insurance is skyrocketing. Anything we can do to hold it down would increase and improve the economy of not just Nevada, but the country as a whole. And in Nevada, they realized that if they restored some semblance of sanity to a system that had been hijacked, it would improve Nevada, and it has. So while Nevada was a success in terms of legislative reform, please understand that it is not a home run win for the insurance industry. There are many aspects of the legislative change that were not favorable for the insurance industry. But as we always say, and I don't know how many mediations you've done, but I'm in mid 4 figures in my career. I used to do them 2 and 3 a week. They say that if both sides walk away unhappy, it's a win. And that is essentially what happened in Nevada. I can give you some examples if you'd like.
Yeah, I think that it's important that obviously we talked in, a broad perspective on the changes. Let's talk about how this actually impacts day to day, right? So I think some examples would be fantastic. Let's do it.
In the work comp carriers column, the new legislation, which amended section 616C.215, which is the main subrogation statute in Nevada. Every state has a statute. Some states like California have written War and Peace, and they call it their subrogation statute. Other states have 2 short paragraphs, and that is their subrogation statute, because work comp in every state is statutory. It's not equitable. It's not contractual. We don't subrogate based on the terms and the right to recover from others clause in the work comp policy, even though it's there. But the states have said Your right to recover is a statutory right. It should not, even though some states don't listen to this, it should not be an equitable right, which would be subject to equitable defenses like made whole and common fund, but instead it's statutory. This is the legislature's prerogative, and they decide what the law is. So in Nevada, the changes included things like subrogation now expressly includes UM and UIM proceeds. So if you look at the cross-section of 51 jurisdictions, including DC, a large preponderance of states do not allow a work comp carrier to recover from a UM or UIM policy, period. Some allow it from the employer's policy and not the employee's policy, but for the most part, the majority say no. Nevada has now said that they are going to include any recovery from an employer's UM and UIM policy. All right, so that's good for the work comp carrier. On the other hand, the legislature gave, and it also takes away. The new statute in Nevada also adds a dramatic cap, which is unique in the country, on a carrier's subrogation lien. That's not good. But they limit recovery to the lesser of the actual lien amount or 1/3 of the total third-party recovery. So if there's $100,000 policy limits and there's a $150,000 work comp lien in Texas, guess what happens? The carrier gets $100,000. Well, it doesn't seem fair if you're advocating for the injured employee, but that's the way it is in Texas. However, in Nevada now, you are entitled to recover only 1/3 of that $100,000, and your right to recover your $150,000 lien is capped at $33,000. So that's a win for the plaintiff, who now can be assured of a recovery if there's minimum limits. Okay, in the insurance company's column is the new provision that there are no attorney's fees to which the employer or the work comp carrier has to contribute. Overruling Breen, as you said, the case that was actually contrary to the statute. At the same time, litigation costs now are still partially shared, but the work comp carrier, instead of owing only a pro rata share, owes up to 50% of the reasonable litigation costs, and they have to be verified. So that's bad for the insurance company. The future credit rules are now overhauled and greatly restricted, whereas before a future credit would have been whatever the employee pockets, the work comp carrier can stop making payments until that amount is exhausted. Now they've done something, again, unique to American jurisprudence, where they've said the credit now, if you have let's say a $10,000 medical payment after the third-party settlement, normally the plaintiff would have to pay that out of the money he recovered. But Nevada is saying that payment is reduced by no more than, let's use an indemnity example. If a $10,000 indemnity payment would be reduced only by 1/3 and no more. So the work comp carrier does not get to take a true vacation. They just pay a little bit less on each payment. And even worse for the carrier is now the future credit applies only to indemnity payments and not to medical payments. So that's bad. So why are we celebrating the legislative change in Nevada that was effective at the end of May? Because it's a heck of a lot better than what the activist Supreme Court had left us with. But on the good side and on the insurance company's side of the ledger, there are clear notice requirements. The plaintiff, his attorney, and the third-party carrier have to all notify the work comp carrier within 15 days of receipt if there's any sort of a settlement, and they have to provide an itemized breakdown. As you know, which can be horribly difficult to get from plaintiff's counsel who simply has been trained to ignore a work comp carrier. But moreover, it becomes only the second state in the country after Texas, which now makes the injured worker, the attorney, and the third-party carrier all jointly and severally liable for any unpaid lien amount. They didn't pay your lien in Texas and in Nevada, no problem. You can go after the attorney. You can go after the third-party carrier. So guess what? Everybody's really careful to make sure that liens are paid.
And you want to do it right. You want to do it right in that circumstance. Absolutely.
Yeah, so on and on it goes. I mean, there are lien assignment restrictions now where in many states you can assign your lien to the third party and say, hey, I'll give you a $50,000 coupon today only, $50,000 off whatever you owe to the plaintiff, and we'll only charge you $20,000 for it. And that was a rather slick way of getting repaid a significant portion of your lien even before the case settled. You can't do that in Nevada anymore. There are also other special jury instructions. Nevada is now unique, or among only a handful of states that allow the jury to be told, contrary to the collateral source rule, that yes, this employee, this plaintiff who's coming before you, asking for you to award him or her money, he actually received a bunch of money in the form of work comp benefits. Most states under the collateral source rule say, no, the judge will tell you that the attorneys cannot advise the jury that he received money from that collateral source, work comp. But in Nevada, they now provide that juries can be instructed, but also that they have to be instructed that that money is going to be paid back. So there's no hiding, there's no shell game anymore. So as you can see, Nevada is sort of a mixed bag, but what makes it a success is this was the perfect example of legislative compromise in action in a state which badly needed it.
Thanks, Gary. I mean, I think that is really the big takeaway for the audience is just the sheer extent of changes, right? Now we understand kind of the basis for it, right? Adding some clarity, right? A grand compromise between, you could say, kind of the way the insurance industry and the plaintiffs bar. But ultimately, it sounds like we're much better. It's moved up from one of the worst to one of the better states. And all of our clients who handle work in Nevada, they could rest assured that things are better, that we are here to answer your questions. And still, if you need counsel in Nevada, MWL is here to help. Right, Gary?
Absolutely.
All right. Now, anything else on Nevada before we jump on over to the recent changes or proposed changes in Nebraska?
Well, one last thing, I guess, is that when you have legislative changes and amendments and bills that pass, you have to pay special attention to when that bill becomes effective. In this case, Senate Bill 258 became effective on May 31st, 2025. What that meant for our industry and any listeners today is that on June 1st, the game completely changed. If you didn't know that bill was coming out, and many plaintiffs' attorneys are kicking themselves because they didn't settle their case on May 30th. And May 31st rolled around, and now retroactively, this bill applies to every case that hadn't settled up till that time. And that is rather unusual. A lot of times bills will put a dividing line and a white flag in a certain date based on when the cause of action accrued. So older cases which had been operating and being litigated for years on the assumption that the old pro-plaintiff statute applied now wake up on June 1st and realize that, oops, we have to completely rethink this entire case. So practitioners should check with us if they have a case and it's going to mediation with regard to the new changes and how it's going to affect what they do.
And that's a lot of the questions we've been getting recently. It's, hey, here's the facts. Plaintiff's attorneys arguing this. We're pretty sure that the new statute applies. What do we do? Right? And that's where I think Gary answered that. But if there is additional clarification that you need, anyone on this podcast, feel free to reach out to Gary with those questions. He is happy to answer or direct you to somebody who can. So beautiful. Well, that's Nevada. Let's move on to Nebraska now. So now, Gary, I know that you and I have discussed this quite a bit, and we've actually been brought in to give some assistance in possibly working up some new approaches to Nebraska work comp. Tell me a bit about what's going on, where things stand, and any changes that may be put into place.
Yeah, it's funny because right before we went live today, my legal assistant came in the office and handed me a publication. I'm not going to say the name of it because she said, "Do you want this?" And I go, "No, I don't read that. I don't know what it is." And she got ready to throw it in the trash can. And I said, "Wait a second." And I looked at it because I saw an interesting article in front. It said workers' compensation and the intentional act exception. And I thought, oh, that might be interesting. And Mark, one of my partners, was in the office here with me. And he goes, "Oh, yeah, that might be interesting." I turned to it and it's my article. I hadn't even realized that I had an article in the magazine. And my point here that I'm trying to illustrate is that I think Matisse and Wickert and Lair has sort of accomplished a ubiquitous pervasiveness within the industry, which is exactly what this industry needs. Is we need advocates for subrogation to be found everywhere. And when you mention Nebraska, which had, similar to Nevada, a problem because of an activist Nebraska Supreme Court, they had lots of problems with work comp subro. And again, we can do a whole podcast on the history and the purpose of workers' compensation. But trust me when I say it doesn't fit into any nice little hole or square hole in American jurisprudence or American history, because it was essentially a socialist idea whereby we decided that if a worker was going to be seriously injured, we were going to put the onus of that responsibility, medical expenses, lost wages, permanent disability payments, on the employer, even though the employer was totally innocent. In our tort system, we punish those who are negligent, who either carelessly, recklessly, or intentionally cause injury or harm or damage. But in work comp, it doesn't work that way. Work comp is sort of unique. And so throughout time, starting in 1913, 1911 being the first state in Wisconsin, we have passed these laws and made innocent small businesses whose employees are hurt through their own carelessness and not the carelessness of an employer. We've made the employer responsible for literally millions of dollars in medical expenses. Now, they don't have millions of dollars, so they have to buy insurance. But that insurance comes at a cost. And that cost is the work comp premiums. And so what we're seeing is that these states who have been ignoring work comp subro have been ignoring their small businesses and making it more expensive for businesses to open and flourish in those states. So in Nebraska, what we had was another crazy case in which the Nebraska Supreme Court came in and said, I know we have a statute that says the work comp carrier gets to be reimbursed when there is a third-party recovery against a tortfeasor in a work comp situation. We understand that. We're going to ignore that. And we've just decided that the fair thing here is that when there is a third-party recovery, we are going to allow the court to look at the lien and say, we're going to only let the carrier recover what we think is fair and equitable. And I can tell you that judges who are very plaintiffs-oriented are going to, and have in many cases, literally annihilated work comp liens, which again now means that the carrier has to pay it all, that the loss history and the risk modifier for the employer goes up, his premiums go up, the cost of business goes up, there's less money to pay their employees, and ultimately a business fails. You can see the cascading effect of active judicially or legislatively active courts when they do this sort of thing. But in this case, there was a Nebraska case called Cromer versus Omaha Track Equipment. And the carrier had a $200,000 lien. There was a clear tortfeasor at fault with plenty of insurance limits. A settlement was made, and the court said, I think it would be fair and equitable if the carrier got zero. Now, we can all laugh at that and say, well, how is that fair? Well, it doesn't matter because the court has complete discretion. So that's the backdrop that you had in Nebraska. But in Nebraska, and I want to say that this is actually one of my proudest moments as a subrogation lawyer, when the state of Nebraska, and in particular an advocacy group there called Nebraska Work Comp for Equity and Fairness, came to us and said, we recognize you, Matisse and Wickert and Lair, as an industry leader. We know we have a problem here with our radical courts. We want to have the legislature fix this problem kind of like they did in Nevada. Only Nebraska started swinging for the fences. They came to us and asked us to draft a new bill. And they said, please copy the legislative workers' compensation paradigm that you have in Wisconsin. Now, if you recall, Wisconsin is one of the top 2 work comp states, subro states in America. And Wisconsin has a formula. If there's a recovery, nobody guesses. A court doesn't get to determine what's fair. None of that nebulous stuff. Instead, a formula has to be followed strictly. The first third of any recovery, well, the attorney's fees come off the top. The first third of what's left goes to the employee. Note that the carrier still hasn't recovered anything. But out of anything remaining, the carrier gets reimbursed. Then if there's anything left over, it goes to the employee, and that amount constitutes a future credit. It's a very fair and workable formula that Wisconsin follows. Nebraska wanted to copy it. So Matt Fricker, one of our subrogation work comp gurus, and I were asked to draft the bill, and we did. We drafted Legislative Bill 313, legislative bill because Nebraska is unicameral. They have only one house in their legislature. And in January of 2025, our bill, Legislative Bill 313, which was word for word what we proposed, copying the Wisconsin statute, but we had to weave it into the Nebraska paradigm. We were asked to do that. And fortunately, we were able to have our bill submitted exactly as we built it. That's pretty cool.
That's fantastic. And where do things stand? I mean, is this just being, has there been any pushback, any impact? I mean, where do we think things go from here in Nebraska?
As in the court system, there is no easy and simple route to success. Legislative Bill 313 was introduced in January. It copied the Wisconsin statute. It did not advance as a standalone bill during the 2025 legislative session in Nebraska. It achieved kind of a partial but meaningful victory when several of its provisions were amended into Legislative Bill 455, which was a broader omnibus bill that covered things like more structured issues within the work comp system and incorporated a lot of the key provisions of Legislative Bill 313. And not to get too boring, but the language in Legislative Bill 455 actually passed on June 6, 2025, and adopted the basic core provisions that we had included. But, and this is the significant but, it was never signed into law as a standalone bill. It was advanced from committee to committee. I don't profess, and I believe you know a lot more about legislative inner workings than I do, but time ran out under Nebraska law, and it ran out in the legislature's final days, and the bill was never called for a floor vote. So even though we had partial success when the legislature adopted part of our bill, it stalled before final passage. But everybody in the legislature is now aware of the problem and the need for a solution. So prior to July of 2025, there had been no reform enacted in Nebraska. So I'm the advocate, and this was our sponsor was Senator Bob Hallstrom in the Nevada legislature, and he advises, and they remain very optimistic that some of these changes will be resurrected in the next session. So sometimes just having them aware that there's a problem is a victory. You know, Nebraska still has its problems, which require subrogation counsel more than ever, but we're hopeful we can make changes in the future.
Of course, and that's a win in and of itself. I mean, we started off this episode talking about kind of the lack of attention to subrogation over the years. The fact is, there's now attention, right? We're looking at these two states as examples of state legislatures, I mean, actually being willing to consider subrogation-specific legislation, which is a huge victory in and of itself. I think that's important. I mean, other states, you know, I think that we're kind of getting close to our time, but I mean, look at Georgia, right? We talked about Georgia, the worst state for subrogation, you know, above and beyond, I mean, so far beyond anywhere else, right? In Georgia, if benefits are paid in another state, incident occurs in Georgia, you just can't subrogate. Your claim's barred. But if somehow you're one of those lucky ones where benefits are paid in Georgia and the accident occurs in Georgia, well, made whole's codified. So you're pretty much going to get pennies on the dollar anyway, but for some creative approaches that we've developed and been successful. So what do you got to do to change Georgia, Gary? You know, what's our next step there?
We have taken steps to do that. I have twice written to every single legislature on both sides of the aisle in the Georgia legislature and explained why you are not simply helping poor, innocent, injured victims. You are penalizing all of Georgia's businesses, large and small. The larger the business, the bigger the penalty. And when I say penalty, I don't mean just a small penalty. I mean hundreds of thousands, and in cases of larger corporations, millions of dollars paid in additional premiums because no subrogation rights exist. Do they exist? On paper, they do. But as you mentioned, Georgia says, hey, if benefits are paid under the laws of any other state, and if you're injured, let's say in Georgia, but you happen to be a Texas company or a Florida company or a South Carolina company in Georgia at the time, you most likely will receive benefits from one of those other states. Georgia has, in its infinite wisdom, determined that because the statute contains the words paid under this chapter, that means if it's paid under the chapter of any other state, there is no subrogation right, which is ludicrous. That wasn't even contemplated. No one who signed or voted for that bill even understands that you could have a conflict of law situation, but that's what the court did. Why? Because it favors the plaintiffs. Likewise, there is no credit in in Georgia. If there's a large recovery, if the plaintiff recovers $200 million and decides to go buy a yacht, the work comp carrier, i.e. the small employer, it could be a small pet shop for crying out loud, is still going to be paying unlimited medical, permanent partial disability. There's no credit. And that to me is criminal and should never happen. But yet it does in Georgia. And there's other states. We've also written to the Illinois legislators. In Illinois, I mean, we all know basic premise. Hey, if you're an employer and you have work comp coverage, your employee can't sue you, right? That's the basic premise. That was the societal compromise, which at the turn of the last, or 2 centuries ago, I guess is what you'd say, in the beginning of the 20th century, when work comp first came into existence, that was a purpose. It was to prevent employers from being sued by employees. But guess what? In Illinois, you can now have contribution against employers. What does that mean? That means if an employee sues a third party, the third party can sue the employer and say, look, if I owe anything, you owe something if you were partially at fault. Well, that doesn't work because now essentially the whole exclusive remedy, the purpose for work comp in the first place, has been neutered. California,
Right.
Same thing. I mean, California, you can say an employee can just settle around a work comp carrier and no work comp recovery is had. That's not what was intended. That's not why we have that system. So, yeah, there's lots of states that need reform. We're trying to bring this to people's attention, but I think the biggest enemy we have, and no offense to those people who devote their time and energy in the legislature, but I think a lot of the legislatures are simply ignorant when it comes to subrogation. That doesn't mean they're dumb. It just means that, as we started off this talk discussing, I would say that less than 10% of them even know what the word means.
Absolutely. And I think the important thing for the audience is most of us, if you're listening to this podcast, I'd imagine you probably have something to do with insurance or subrogation. And if that's the case, we encourage everybody, stay up to date on your state or the state that you are handling most of your claims in, their recent bills, legislative changes. Advocate, right? Advocate for these changes. Reach out to your state legislator, your local elected official, your state rep, your local congressman even. And just kind of make these things clear. Stay up to date, know the changes, know what's being considered. Because, sure, insurance companies, corporations, they have, lobbyists, they have interest groups, but they still don't vote, right? So it's a lot of times, these decisions are relatively skewed towards the injured people because, those injured people are out there voting. Sure, obviously money matters in politics, but votes do too, which is good. But ultimately, I just encourage everyone, stay up to date, listen to podcasts like this. We'll keep doing summaries as to any changes that come in place, any changes that are on the horizon or being considered. So just tune into the podcast, stay up to date, reach out to Gary Wright with any questions. I know this stuff's relatively complex, but, you got to learn to keep progressing on these things. So,
all right. Well, thank you for having me, Ashton. This has been interesting.
Of course. Well, hey, Gary, I appreciate your time. Audience, I appreciate you all. Until next time, Gary, I'm sure you'll hear from me again soon on another fascinating topic to discuss.
Thank you.
All right. This episode of the Subrogation Support Network podcast is now over. Thank you, audience. Thank you, Gary. Until next time.